morning, everyone. My name is Frédéric Gontier. I'm in charge of this webinar series together with Marie-Estelle Binet. And I will begin with a very brief opening statement to greet the audience to this third webinar and to remind that this webinar series is meant to promote world-class scholars and research programs carried out in Sciences Po's research centers. And this is doubly the case today, given that our speakers come from two different but equally dynamic research units, PACTE on the one side and CESICE on the other side. As most of you are aware of, in addition to being the director of Sciences Po Grenoble, Sabine is an accomplished scholar affiliated to PACTE. And as regards Fabien, next to his role of Director of International Relations at Sciences Po, he is also Deputy Director of the CESICE, as well as Jean Monnet Chair in European Laws and Politics. Sabine and Fabien have teamed up to address the topic of normative transformations in the European Union. And I'm tempted to say that this is the magic combo for this kind of topics, since political science and research in European law can definitely work their magic together on highly institutionalized research objects such as European Union politics. The lecture that they are going to deliver today follows on from a special issue of West European politics. Their talk will be discussed by Chloé BERUT, who also contributed to the special issue and who recently received her PhD in political science under Sabine's mentorship. Congrats to her. But let's get to it. And without any further ado, I give the floor to Sabine.
Thank you tremendously, Frédéric. I'm very, very happy to be here together with Fabien. I'm very happy about this webinar series, which functions perfectly well. Today we are going to talk about a extremely timely topic, but all the topics that we are talking about in this webinar series are timely. So this is no big surprise. And again, congratulations to Frédéric and Marie-Estelle Binet and the communication services for preparing this webinar series. And I do hope that we have interesting things to say to you. So the timely subject of today is, do European crises lead to less integration? And what we would like to do is to illustrate this case and to answer this question by looking particularly on the issue of the hardening and softening of EU law in particular. So Fabien is the one who is dealing with the with the PowerPoint, and I'm just talking. So why is this question particularly interesting today? It is particularly interesting because when we look at it from a slightly historical perspective, and I do hope that we don't have too many historians in the audience, because they will tell me, well, you know, late 1980s, it's not really historical. And nevertheless, for a political scientist as I am, late 1980s, you know, is last century. So what we saw in this period is that European integration was described, analyzed as integration through law. What did we see? We saw an increasing number of directives and regulations, in particular after the Single European Act and the Maastricht Treaty, which were controlled both by the European Court of Justice and national courts. In the 1990s, we were confronted with a slightly different situation, the end of this famous permissive consensus, meaning that European citizens all of a sudden didn't buy what their governments told them about the European integration any longer, without questioning, without criticizing, without saying, well, we would like you to be accountable to us. So didn't accept everything that has been decided at the European Union level without questioning it. And the community method was equally challenged. What does that mean? That means that this famous method where European institutions decided on directives, regulations, and decisions was enlarged towards more intergovernmentalism, soft modes of governance, or as we called them at that time, the new modes of governance, mostly based on soft law rules, these new modes of governance. So all of a sudden we had something that changed. We still had regulations and directives, but we also had more soft law. The recent migration and refugee crisis shows that the EU had some difficulties to find common legal instruments. We also saw a momentary suspension of the Schengen Agreement, a questioning of the Schengen Agreement today, very clearly from both member states and European institutions, and particularly the Commission. And the alleged softness of the EU's legal answers to climate change. So therefore, question, is there a slowdown of integration through law? And we can move on to the next slide. At the same time, there is a group of scholars, extremely well-known group of scholars, that argue that the EU law is not being softened. The EU seems increasingly to rely on the rule of law. A couple of years ago, a colleague of ours, Dan Kellerman, published a very influential book in this debate called Eurolegalism, where he argued that the EU creates many rights and other legally enforceable obligations, and then depends on national courts and interested private actors such as firms, citizens, or interest associations to enforce them. So what we see is really a judicialization of policymaking throughout Europe, and not so much the end of integration through law. Examples don't lack. We see a strengthening of the legal framework as an answer to the economic and financial crises in 2008. We see a legal steadiness of the European Union confronted with Brexit. This was really something that you have to imagine. We had from 2016 onwards to 2020 negotiations going on with the UK, and we didn't have one single time a situation where one of the member states of the European Union said, we disagree with what the European representative says to the UK. This is a situation that has never happened before, and therefore an argument for this group of scholars saying EU is still relying on integration through law. At the same time, we have people saying that, well, you know, even if softening and differentiation would take place, this really is a dangerous perspective. So they take a normative stance and say, well, you know, guys, if you open up this whole thing and make it differentiated and, pick and choose system, then we really would create a European Union that is open for some things and not for the others, and therefore a possibility of differentiation and a situation in which power games become much more important than the rule of law. Empirically speaking, however, both phenomena do indeed take place. Therefore, our question, and we are coming to the next slide, which interpretation is correct? Or let's reformulate that. When is which interpretation correct? So then when do we observe softening of law, and when do we observe hardening of law? when and why, and this is our research question, do EU actors decide to adopt legal arrangements, therefore hard law, and when and why do they opt for more informal frameworks, soft law at the European Union level? Why is this an important question? Why? I mean, it's important for social sciences, of course, and we are social scientists. But why is this important for a general debate? It is important because it allows us to understand the transformation and the nature of law in society, in a political system. Every political system is based on law, and therefore understanding this transformation really helps us to understand the political system as such. And as far as the EU is concerned, at a time when disintegration seems to compete with integration processes, understanding this transformation really helps us to understand the forces with which we have to cope in the European Union. Next slide. So this project, just very quickly, is in fact a result, and we are very proud of that, of a Université de Grenoble-UGA, a UGA sponsored research project called T-Norms, Transformation of Norms, that was awarded to Fabien TERPAN and was then transformed with lots of absolutely fantastic colleagues into a special issue of West European politics that is already available on the web. It's the first issue of 2021. And it has been used as a starting block, as a basis for two other research projects in which Fabien and I we are integrated, which is the famous EFSO law project, the Effects of Soft Law project, a ANR and DFG funded project, a Franco-German project, together with Miriam Hartlab from the Free University in Berlin, and secondly, a H2020 project called EU 3D Grant Agreement that is headed by the ARENA from the University of Oslo on the question of differentiation, democracy and dominance in the European Union. Next slide. Okay, and therefore I think I give the floor to Fabien for the rest. Thank you.
Yes, thank you, Sabine. Thank you very much, and thank you, Frédéric, and the organizer of the webinar. The following slides are focusing on the article that we have published in this special issue of West European politics. So it will be a way for us to explain how we dealt with this question of the hardening and the softening of law. More precisely, the question here in this article is the following: why and under which conditions do crises in the Union lead to the establishment of hard law, or alternatively to the establishment of soft law? So explaining, as Sabine said earlier, the hardening of a policy, because here we are studying three policies, the hardening of a policy or the softening of a policy. This is based on a definition of soft law and the categorization of soft law derived from an article that I published in 2015 in the European Law Journal, which was an adaptation of Abbott and Snyder's work on legalization, actually. And this, for us, actually, this was a starting point of our research on soft law and hard law. We needed to have a definition. So as a lawyer, I focused on this topic and came up with a definition based on two main elements. The existence of an obligation, the first element, and the second one is the existence of an enforcement mechanism ensuring compliance with the rule. And if one of these two elements is weak or is missing, then this is soft law instead of hard law. So basically, our two categories in this article are made of, when you look at hard law, legally binding acts such as directives, regulation, decisions, with an enforcement mechanism. So sometimes it can be controlled by the European Court of Justice or other forms of enforcement. And the second category, soft law, is made of non-binding acts such as recommendations, guidelines, this kind of soft acts with sometimes a kind of monitoring, surveillance mechanism, a kind of soft enforcement, even if it seems to be an oxymoron, but it's kind of enforcement in a soft way. So the three policies that we have chosen to study are budget monitoring, migration, and cybersecurity. This is, first of all, linked with our dependent variable, actually, the hardening or softening of a policy. We needed to have policies where we can find both hard law and soft law, and we needed to have policies where we witnessed some kind of change, policy change in the number of soft acts and hard acts, which is the case with these three policies. But the reason for choosing the three policies is also linked with the independent variables, in particular the crises. We needed to have three policy areas where crisis had occurred. And again, this is the case with the three policies. Budget monitoring, you have a crisis, a sort of crisis in the early 2000s with the Stability and Growth Pact at that time, which was not functioning as it was meant to be. And you have the economic and financial crisis since 2009 to 2010. The migration crisis starting in 2015, and the cybersecurity crisis, we identified the crisis in 2007-8. At that time, there are several cyber attacks on a number of member states, in particular Estonia, but also France and Germany. However, we observe, and we will, I will come back to this, we observe in these three cases that the crisis leads to a hardening process in the case of cybersecurity, for example, or budget monitoring since 2010. But in the other cases, on the contrary, the crisis led to a softening process. In terms of the methods we use and the conceptual approach that we used, so the method is quite simple in a way. We count the number of acts per year and we place it in our category of soft and hard law in order to come up with a proportion of both types of acts in the three policy areas. There are a number of difficulties. Maybe I'm not going to elaborate on this for reasons of time, but just a little, one element. of course, just counting the number of acts can be misleading. You also need to look at the content of the act. But it's a first element that you need to take into account, the number of acts. So we're not saying that this is the only element that you need to take into account, but it's a solid basis. And then you can complement this analysis by looking at the content of the act briefly in order to check a number of complementary elements. And the timing of policy is also a question that is always important to take into account, especially when we look at the effect of a crisis. So when does the effect of a crisis occur, and when can we make a link between a crisis and its effect? And we need to keep in mind this difficulty linked with the timing of decision making in a way. So in the literature, we found 3 potential explanations for policy change, and that we apply to our study. The first one is a crisis center explanation. So basically what we are doing here is that we making the assumption that normative transformations can be explained by the size or the intensity of a crisis. So the first explanation would directly answer the question, and the 2 other explanations are complementary answers. A feedback-centered explanation that would be linked with a weak implementation of existing rules. So the idea is that the hardening of a policy, or maybe it's softening, could be a reaction to a weak implementation of existing rule, or the perceived weak implementation or the perceived failure of existing rule. So rules are not working, we are changing them, and it takes the form of either hardening or softening. The last explanation is actor-centered. We looked at entrepreneurs creating coalitions, and especially heterogeneous coalitions. The entrepreneurs that we are looking at, supranational institutions, and in particular the Commission, and the member states. So we take the member states as possible entrepreneurs. We also have a definition of a crisis. I won't elaborate on this, based on 3 main elements: threat, surprise, urgency. But we need to have this definition in order to give a kind of measurement of the severity or the intensity of a crisis. Now the results of our study. First of all, the first policy budget monitoring. As you can see on this graph, you have we can make a distinction between 2 periods, before and after 2010. So before 2010, let's say that we have basically the Stability and Growth Pact, which is revised in 2005. If you look at the content of a revision, it's a revision towards softness. And then in 2010 starts a period of clearly hardening of this policy with the so-called 6-pack, 2-pack fiscal compact in the context of the austerity policies developed within the European Union, which take the form of regulation, directives, so hard acts. When we look at the explanations, so before 2010, there was implementation problems in a way, because the Stability and Growth Pact was not working as it should have worked. But the crisis is less intense than the crisis starting in 2010, and the entrepreneurship is not a factor that is present here, because we only have the Commission, in fact, with the support of some member states, but France and Germany are against the hardening of this policy at that time. So this actor-centered explanation here doesn't work in a way. We do not have this entrepreneurship creating a coalition. Whereas in 2010 starts a period where the three factors are present: the severe crisis, problems of implementation, and this time entrepreneurship, with Germany joining the Commission as policy entrepreneurs and succeeding in creating a larger coalition, including France actually, in support of a hardening of the policy. Migration now. Migration, you also have two main periods, before and after 2015. Before 2015 is a period where you have a number of hard acts, which is quite important. So we would depict this period as a period of hardening of migration policy. But clearly in 2015, as you can see on the graph, the number of soft acts increased tremendously. So in 2015, 2016, 2017, it is really clear. And this soft law, when you look at the type of soft law, is very often compensating for the lack of hard law, or to say it differently, a hard act was proposed, it was refused, then an act was adopted in the form of soft law. So in order to compensate for the non-adoption of hard law. So when we look at the explanations, we have clearly one element which is missing in the most recent period, the soft period, I would say, and this is entrepreneurship and coalition. The other elements are present. The crisis is quite intense. The rules are not respected. In particular, the Dublin regulation is not working anymore. The regulation on asylum is not working anymore. So the problem here is clearly with the entrepreneurship. The Commission, France and Germany act as policy entrepreneurs, but they do not succeed in creating a coalition. Finally, cybersecurity, more difficult to analyze, but we have what we have identified here. It's less obvious when you look at the graph, but here we need to give complementary information on the content of the acts. So since 2013, there is clearly, with two directives on this field, we have an evolution towards hard law. There is still soft acts adopted at that time, but they are complemented with hard law in the form of directive. And when we try to find out which explanation works best, or it's also a little difficult, but we come up with a conclusion that we have a combination of a three explanation, even though it is at a lesser extent than in the case of budget monitoring since 2010, for example. But there is a crisis, there is a problem of implementation, and there is entrepreneurship, in particular the Commission and France, acting as entrepreneurs and succeeding in creating a coalition, even though Germany at that time was rather reluctant and opposed the proposal made by France and Commission. So the conclusion that we make, there are four remarks that we can make based on the results. So general remarks. First, a combination of the three factors leads to a hardening of law. So in two cases, at least, cybersecurity and budget monitoring since 2010, there was a combination of the three factors. And when one of the factors is missing, then the hardening doesn't occur. The second point is the impact of crisis. And this impact varies. Crisis situation can trigger the hardening of a policy, as shown in the case of budget monitoring in 2010, and cybersecurity to a lesser extent. But crises are not a sufficient condition for hardening to happen. And the case of migration in particular shows that hard law can be used outside the context of crisis. And on the contrary, soft law is widely used in a period of crisis. Third comment, on the weak implementation of existing norms is sometimes correlates with the use of hard law in two cases, budget monitoring and cybersecurity. But sometimes it doesn't. So the first crisis of the Stability and Growth Pact, for example, and migration is also an example. So it's not enough that the policy is perceived as not functioning efficiently in terms of norms application. There is a need for other factors to be present. And my last comment is about the entrepreneurship and the coalition. The coalition is always needed, which in a way is not a surprise. But what is more interesting is the link between entrepreneurship and the coalition, and the fact that the Commission, when the Commission acts alone, the Commission as an entrepreneur is never sufficient. So there needs to be a support from the member states. So those who are saying that the Commission rules the European Union are wrong, at least in these three cases. Most probably, the big member states need to be part of the entrepreneurship and the coalition, because when two member states oppose the entrepreneurship, like France and Germany did for the revision of the Stability and Growth Pact in 2005, then the revision was not possible. At least it was not possible in the direction of a hardening, so a softening occurred. And at least one member state, big member state is needed. In the case of cybersecurity, there is France. Germany is not among the policy entrepreneurs in this case. So the policy, the big member states are often part of the entrepreneurship, but what is also striking is that the entrepreneurship of big member states is not sufficient either. So when France and Germany proposed hardening of a migration policy after 2015, together with the Commission, they also failed to create a larger coalition. So those who are saying that the EU is ruled by Germany or the EU is ruled by France together with Germany, it's not true. At least in some cases, it doesn't work like this. Finally, our last slide, and I give the floor to Sabine for a more general conclusion.
Thank you, Fabien. I do believe that the comparison of three distinct policy areas shows really that overall conclusions hastily drawn can be quite problematic, and this is particularly what our study shows. To be careful when we come with overall conclusions very quickly, as we all know. But I would like to conclude in saying that in this situation in which the EU is described as being in a polycrisis, to which the pandemic adds even more, in this pluri-crisis situation or polycrisis situation, I think working on a study that tries to understand when and how a political system decides which acts should be considered as hard law and which areas should be managed through soft law is not only an academic endeavor, as we try to do, but also a democratic one. I think we really need to understand that, both, of course, in the case of the European Union, as we are doing today, but I think it's a general question that we could ask for our political systems more generally. So the question how a supranational system reacts to stress, which are the limits and where improvements can be found and sought, are an important question to ask for every research project, and in this case really contributes to a better understanding of political systems and societies in which we live. So thanks a lot for your attention.
Okay, is this my turn? Right. So first of all, thank you very much for inviting me to discuss this paper, which of course is closely related to what I study, which is the implementation of EU soft law at the domestic level, but is at the same time quite distant methodologically speaking, because in my research I didn't have the chance to really study how and why EU soft law is created. So it's very interesting for me. So thank you very much for your presentation, which was very clear as usual. I liked very much all your graphs and figures, which are far more clearer than in the article. I think it's just because of the color. So it was nice to have them on the PowerPoint. And so I think that soft law is really a fascinating subject, and that studying the relationship with crisis is very interesting, and in particular in the view of recent events. So before going into more details in the paper you presented, I wanted to talk a bit about the approach you used in this paper, but also more generally in the special issue on normative transformations in the EU that you edited in West European politics. And so the way I learned about soft law when I was a student here in Sciences Po Grenoble was mainly related to the area of social policies. So as you said, the main idea was that in the 19th, European integration became difficult. And so member states and European institutions decided to use these new modes of governance, so using soft law, but also policy coordination devices such as the open method of coordination, to keep going with the integration process without the member states losing their sovereign power over these very sensitive areas. And so in my mind, at this time at least, soft law was a sort of weak substitute for the real integration process, which was meant to occur through hard law only. And I think what this research shows, as well as the whole special issue in West European politics, is that this perception of soft law is actually quite reductive, and that soft law is better understood as a specific way of governing with its own way of functioning, its own instruments, its own set of effects, and also its own explanations. And as regards this last element, we understand very well when reading your paper that soft law is not just the result of rational member states and European institutions thinking about how to proceed with European integration, but it is rather the result of multiple dynamics occurring at the EU level. And so in your paper, you study three different dynamics, which are the magnitude of the crisis, feedback effects linked to previous implementation failures, and the role of member states, coalitions at the EU level. So first of all, I wanted to come back to this notion of crisis, which is very important, of course, in the paper, because, and you say this in the paper, what is a crisis is linked to real events in the real world, but it is also a frame by policy actors. And by the way, it's always fascinating to see how similar deterioration in indicators may lead to very different policy responses, depending on the context. So in the paper, you are very clear about the criteria allowing you to define a crisis, which are situations which threaten the high priority goals of the decision-making unit, surprises the members of the decision-making unit by its occurrence, and creates a situation of urgency and restricts the amount of time available for response. So first, I just had a short methodological question about the measure of these three elements, because in the paper and the presentation, we know a lot about the measure of the dependent variable, but not much about the independent variables. And so given that we know that the crisis is also a frame which can be socially constructed, I just wanted to know how you realize this measure. Is it through interviews or more objective elements? And if yes, how did you mix all this together? Anyway, I am quite convinced that the problems policymakers have to deal with are not always on the same level of intensity, which might be important in your explanation. But at the same time, I was wondering if the idea to put a threshold to define a crisis is really that useful in the explanation. Because, and I think it's especially true in the cybersecurity case, sometimes it becomes hard to really make a difference between a problem simply being put on the European agenda, which can be linked, for instance, to a focusing event that requires an immediate attention, or to a negative policy feedback, and a crisis. And finally, this led me to wonder why this concept of crisis was really useful in the end in the explanation, and how it was linked to your general arguments. Because I guess that decision-making at the EU level, resulting in either soft or hard law, occurs even without crisis. So the question would be, what are the specific effects of crisis settings on the production of soft law? And are there any differences that we can expect when comparing with times situated outside of crisis, if it does exist or not? And so in the same special issue, Peter Slominski and Florian Troner argue that crisis situations should be particularly favorable to soft law, as they reduce the legislative cost and therefore allow to circumvent usual procedure, which are more heavy and difficult and long and so on. So they say that in the case of migration policies, but I wanted to know if you would agree with this statement, and if yes, how would you integrate this in your analysis? And this leads me directly to my second point, which is about the link between the intensity of the crisis and member states' reactions at the EU level, which are, in your analysis, treated in a rather independent manner. So we understand very well that the intensity of the crisis itself do not result automatically in harder forms of law. But meanwhile, there is some sort of mystery right now in the article about why member states are sometimes willing to adopt more binding measures and why sometimes they're not. And you show well that what happens in terms of consensus building is actually crucial in the explanation. And given the fact that coalitions can lead either to soft or hard law, I was wondering if a part of the explanation you're looking for could not be found in other factors explaining member states' preferences as regards the type of European response being hard or soft. So I guess it would be very interesting to have a kind of typology of factors allowing to define the conditions under which we can expect many countries to be in favor of soft law or in favor of hard law. And it could allow for the integration of domestic factors in the analysis. And it would also allow for the consideration of structural or contextual effects in a way which is more closely related to agency, the agents being member states in this case. So I was wondering if you had some thoughts about these other factors that could explain member states changing preferences on hard and soft law at the EU level. And on a related note, I was wondering how you took into account the fact that some areas are maybe more traditionally dealt with at the EU level. In my mind, for instance, economic surveillance or even internal migration is something that is traditionally dealt at the EU level. And when reading the paper, I had the feeling that cybersecurity was quite new in this regard, but maybe I'm wrong. And so I was wondering if this also could affect what we could expect in terms of hard or soft response. Maybe it doesn't affect this type of response, but it would be an interesting result. But yes, I was wondering if the decision-making dynamics were really that comparable, given the fact that these three countries might not be at the same point of departure. Okay, and so to conclude, I had two other more general questions, which are wider and more open-ended. So first, I was wondering if you had any thoughts about normative transformations occurring outside of the case of the EU. Is the soft way of governing something that becomes more prominent, maybe at the domestic level, or is it just something that remains in the realm of international organizations? And finally, I wanted to know if you had some thought about, of course, the COVID crisis and the effect on soft and hard law at the EU level.
Fantastic, thank you. I think we do have a number of questions. Is this correct? Yeah. Okay.
So, I'm looking at the chat. I know that Amandine wanted to maybe to talk in live. Okay, I just need to go.
Hello. You just hear, great.
Yeah.
Okay. Hi everyone. I also wrote my question because I have to leave in 5 minutes. I have an appointment with the student, but I'm really glad I could attend the seminar today. So there are a lot of unpleasant things about COVID times, but this is one of the pleasant things, right? That I can attend today. My comment is about operationalization, to perhaps push you to be a little bit more fine-grained, although I know it's just a general presentation, so it should already, perhaps it's already like that in a written version of the paper. But in the way in which you rationalize the hardening of law, you actually look at 3 different indicators. The nature of the norm, is it binding or not? The effect of the norm, is it implemented or not? And the number of the norms which have been adopted. And in the presentation, at least, you take all 3 together. And I was actually thinking that it would be absolutely possible to have a matrix with these different dimensions and find differentiated results on those 3 dimensions. So for instance, you know, what does it mean to have one hard norm and versus 10 soft norms? Or especially what if we have hard norms, and I'm thinking here about the Stability and Growth Pact, but they're not being implemented, versus having soft law with a high level of compliance. So I was wondering whether you do unpack and disaggregate it like this, because I think this would tell a lot also about the politics that are behind the production of norms. And thank you so much for keeping up the extremely interesting work.
Thank you. Thank you, Amandine. Thank you, Chloé. How should we do? Proceed.
I don't know, because there are still some questions on the chat. Do you want me to read them all? And because I don't know how much time we have, but maybe it will be more efficient to do this. So a question from Samuel Suchel. So external actors also have significant influence on EU decision-making and legislation. Do you think that actors coming from outside the European institutions and member states, lobby organizations, NGOs, pressure from third countries, may also impact the choice of the EU to opt for hardening or softening law? Then from Sonia Smerli, I wonder how the acts of member states, governments that are overtly or covertly in defiance of the rule of law can be integrated into your conceptual approach. Mm-hmm. Okay, so Amandine, it's okay. Frédéric, okay. And from Cécile Pelaudet, could the substantive ambition of law be factored in the equation? Could a variance in substantive ambition be also considered as an indicator of hardening, softening law? Mm-hmm. Okay, and that's all.
These are fantastic questions, really very, very useful and very tough questions too, for a tough subject. So I don't know what, Fabien, would you like to start in pick and choose, or should I do that?
I can start if you quite briefly, because I already talked too much. So briefly, I could comment on the factors that could explain why the member states opt for soft law instead of hard law, or vice versa. And I think there was this issue that was raised by Chloé, actually. So in the literature, you have different explanations, but we are not looking at this. Actually, we are looking at how the member states try to convince other actors within to form a coalition and to create hard law, or on the contrary, soft law. But usually in the literature, the explanations are reducing transaction costs. They choose soft law over hard law because they want to reduce transaction costs. When they don't want to do it, they opt for hard law. Sovereignty reasons, soft law is not binding. So for sovereignty reasons, they could opt for soft law. Or the timing, they don't have time to adopt hard law. Soft law can be adopted faster, or simply because they could think that it's going to work. It's going to convince actors without forcing them to apply a rule, but they think it works. So, but these factors, we could not include them in the study. In the West European politics special issue, they are tackled at some point by some of the authors, but we don't do it in the article. The new and old policies, this is you have a point. Actually, it could be an element that we could have taken into account. But at least we have taken 3 policy areas where it was possible to act through hard law. So this does not answer the question, but even in cybersecurity, there was a competence, a legal basis to act in the form of hard law. But this is something that is interesting to think about, actually, and we didn't do it in the article, and we didn't include in the study external actors like I think it's Samuel who asked the question. External actors, indeed, we in our actor-centered explanation we limit ourselves to the Commission and the member states that we considered as important policy entrepreneurs in the European Union. We already did it in a previous publication for policy sciences on the Stability and Growth Pact already, where we decided to apply the multiple stream framework. And in the multiple stream framework, there is a need for looking at policy entrepreneurship. And we decided to enlarge the usual, the most usual definition of entrepreneurship to member states. So to make as if member states could be seen as policy entrepreneurs. Okay, maybe I stop here, Sabine, and I let you give other answers.
Thank you. There are a huge number of questions, and those questions again are not only useful and particularly precise and helpful for future research, but they show also something else. They show that when you start asking, or when you try to answer the question, is there really more integration after a crisis? We all know this myth. Okay, so political systems develop through crises. Okay, and then everything's possible. Okay, this is a myth, and it's at the same time you find it again and again in academic literature. And our question was extremely simple, to say, is this true? Okay, it's a totally simple question. Is this true? Do we observe that? And once you start to ask this simple question, all of a sudden you realize that you are juggling with a number of variables that are just overwhelming. Okay, the number of variables concerning the nature of law as such. So you have to define the nature of law. Hard law, soft law seems very easy, but as you have seen in our presentation, and as you see in the article, it is very hard to pin down, and to choose only 3 of those elements, indicators, the nature, the effect, and the number of norms, is already a reduction that is can be extremely dangerous, and is to a certain extent dangerous. But you need to choose at one point, and you need to argue why this is the case. And then going on to the preferences of the member states, the construction of the preferences of the member states, the influence of non-state actors in this whole debate, become variables that you might add to that. We have decided, because we wanted to compare 3 policy areas, and not only 1 in depth, but 3, in order to get an overall feeling of what is going on there. We have decided to aggregate these elements, which is and can be criticized. I entirely agree with this criticism, but doing otherwise would have needed another research design and another method with other results. These results meaning that you are going much more into detail, and you cannot stay at the general level. So the question The questions you have asked are entirely relevant, and I do believe that you can answer them in another research. For what we have tried to do is to give you a very clear answer in saying, well, you know, we didn't find either in these three areas a movement towards hard law through crises or soft law through crises. What we found, and this is a very clear result, is that the three main variables must be present. That means that you need to have a degree of crisis. I agree with Chloé, very hard to pin down what is the degree of crisis. And again, you select a number of variables and try to explain why you select these variables and not others. Okay, I'm coming back to your question about how to measure the degree of crisis. The second element about the implementation or the partial implementation or the faulty implementation or the problems in implementation. And the third one is entrepreneurship together with coalition. And that's these three very clearly show that when we have all those three variables, then we see a hardening. But when we only have parts of those variables or one or two, the result is much more difficult. Now you could say, well, you know, all this is really fine, but why don't you just call it political will? Okay. You know, for those of you who know me, you know that the term political will is so fluffy and to a certain extent irrelevant that it doesn't cover at the same time the entrepreneurship of some actors and the coalition, because the political will is in fact nothing if it isn't regrouped and defined as preferences, and it can be against a preference, but you still do that. Last element, Sonia's question about the rule of law. What happens if two countries or more clearly define the rule of law? This would be a super interesting case study that we have not included in these three. It would be super interesting, but it would create a huge problem for our definition of crisis, because it is not it's not a moment of surprise. Okay, it's like the crisis of the pension reform, for example. It is a structural crisis, but it is not a crisis that creates a surprise, a situation of surprise where you say, well, now you need to do something immediately, because if you don't, then the whole system crashes down. This is not something that we define as a crisis in our particular context. So I stop here.
Well, if there is no additional question, I guess that pretty much wraps it up for today. Marie-Estelle and I give you an appointment for our next webinar that will take place on the 20th of January, and we will welcome Paul James Caldwell for a lecture on the governance of the European Union external migration. Fabien, correct me if I'm wrong. I guess that's more or less the topic that is going to address.
Perfect. Yes, you're right.
Okay. Well, thanks to all of you for being here, and well, see you next time.
It was brilliant. Thank you, Frédéric. Thank you, everyone. Thank you,
everyone.
Thank you.
Yeah. See you. Bye.
Bye-bye.
Bye-bye.